To talk us through this section, I'd like to welcome and introduce Nick Galle. Nick's the Legal Director of AP Legal and has a lot of experience working in both corporate and commercial law, and has been engaged in a legal capacity on over 300 pharmacy matters, including sale of business, acting both for vendors and purchasers, as well as submitting all the appropriate relocation applications. So talk us through the legal and settlement process, Nick.
Thanks, Chris. So I'll just provide a brief overview of some of the key stages in a purchase of a pharmacy to take the matter to settlement after the heads of agreement or the offer to purchase has been executed. So the first stage that I'll run through is the contract. So it's at this point at the start of the matter where if you don't have a lawyer, now's the time to get one. Pharmacy transactions differ to other transactions and have their own nuances and processes. So it's recommended to have someone who has experience in pharmacy or is specialised in pharmacy transactions. It's also at this time that you need to think about or have your structure ready. So for example, will you own the business as a sole trader? Are you entering into a partnership? Do you need a partnership agreement, with other partners? Or you purchase as a company and, for example, you'll be the sole director and shareholder. So normally your accountant will assist you with this and provide the advice at this stage and what will work best for you. But ultimately you need to decide how the business is going to be owned moving forward. So one purpose of the contract is to ensure that important matters are covered. So for example, restraint of trade. This will prevent the existing owner or includes provisions to prevent the existing owner from setting up next door or competing with you in a certain area for a certain time period. The intent is to stop the existing owner from taking customers or impacting your trade and is necessary to protect the goodwill of your business. Another important component to the contract of warranties. So these are ultimately just promises which the owner will make to you or the existing owner will make to you. An example of a warranty is the existing owner promising or agreeing that all the financial information provided to you during due diligence or otherwise provided to you is true and correct. Another such warranty which is important is the vendor will continue to trade the business in the ordinary course and as is usual until settlement. So such a warranty like this is necessary to prevent an erosion of the goodwill in the business by the vendor. For example, if the vendor weren't to maintain stock levels or current rostering, or just now that the business is sold, for example, they're not going to tend to the customers as they usually do. So these warranties provide you with an avenue to sue if required in the event that the vendor were to breach the same. However, and it's important to you because if the business is not what you originally bought or what you understood you were buying, this may provide you with some recourse against the previous owner. So another important function of the contract is to provide you with security as you move through your transaction. So this is, for example, this is done through conditions precedents. So conditions precedents is a task which must be completed that is necessary for you to settle. So in the event that it can't be completed or satisfied, then you can withdraw from the transaction without any penalty to you. Common conditions precedents will be satisfactory completion of due diligence or receipt of finance approval or consent to a transfer of a lease. So these are just things that you need to happen to get you to settlement. So once the contract has been signed, now the actual transaction commences and the contract will just provide a framework to settlement moving forward, setting out the obligations, tasks, and responsibilities of the parties. So the next major step in the journey to settlement is leases. So this is one of the most important steps in the settlement process to secure your right to occupy the premise. So this will be achieved through either a transfer of a lease of the existing lease or a new lease. So this stage is critical because any of the subsequent pharmacy approvals that you need to trade won't be provided until this step is completed. So securing your occupancy right, this can be a time-consuming and difficult stage as you need to deal with landlords, which will come in all shapes and sizes. So for example, if you deal with a large landlord like a shopping centre, they'll have their own internal processes and procedures which you'll just simply need to follow. This will also include a set procedure on how an authorised person will execute the documents in the end, which can take significant time. Conversely, on the other side, you could deal with a site where it's owned by an individual who may not require anything from you and may handle the matter themselves or just with a local solicitor or agent, and the process can be quite quick and easy. So this stage is also dictated by what you require. So for example, if you, for whatever reason, would like a new lease at the site, well, then a whole new round of negotiations with the landlord will be necessary. As there's no obligation on the landlord to entertain a new lease, this is purely a commercial discussion, and it could be protracted discussions to get the landlord on board and to agree. Similarly, if you're seeking a transfer and a variation of a lease, which is whereby the existing lease is transferred along with a change to the terms of the lease, again, there's no obligation on the landlord to vary the lease, and again, can lead to protracted negotiations. This is typically common where the tenure of the existing lease is short, or there are no options available under the lease. Tenure is important to both the viability of the business which you have purchased, and also will be a factor for your bank or lender, as they'll want to see years on the lease. The final stage here, or the final option available, is to just simply transfer the existing lease. So a transfer cannot be easily rejected by a landlord, and is relatively straightforward. There are very few reasons why a landlord can reject or refuse a transfer. However, the landlord at this stage can ask for evidence as to the financial capability or viability of the incoming tenant, and can request financial information. This will commonly come in the form of asset and liability statements, trade references, previous landlord references, and depending on the information that has been provided or is available, and if the landlord determines that there is some doubt as to the incoming tenant's ability to pay the rent, then the landlord may seek increased securities under the lease by way of an increased bank guarantee or personal guarantees. So once you've secured your lease, you can now move on to obtaining the regulatory approvals. So I'll just briefly touch on this stage, but in the purchase of a pharmacy, you must obtain the relevant state-based pharmacy authority approval and Commonwealth Department of Health approval. As each state has its own authority, there are different applications and timelines will vary between the states. However, generally the processes are the same, as an application is submitted for a change in the ownership, which will be accompanied by supporting materials and documents which are similar, and will include items such as finance documents, any applicable franchise agreements, the contract, and so on. The main purpose of the authorities is to ensure compliance. So, such as making sure the new owner is a pharmacist, and the new ownership structure includes only pharmacists or otherwise is permitted. And also to ensure, for example, that there are no non-pharmacist pecuniary interests in the pharmacy. Department of Health approval will provide you with your PBS approval number to dispense and claim under the scheme, and provide you, and requires its own completion and submission of its own documentation. This stage again has its own processing timelines. The main requirement or the main takeaway for the regulatory approvals is your right to occupy document, which again will come in the form of a lease or the transfer of the lease. So now with the major items to settlement. So those are the major items to settlement. And once obtained, now you're ready to move towards settlement, whereby you will take possession and ownership of the pharmacy. So there are a range of operational and ancillary tasks to attend to in the lead up to a settlement. I will just touch on a couple of items here, a couple of the key items. So one of those being staffing. So prior to the settlement, and in accordance with what has been negotiated or set out within the contract, the current owner will provide you with the opportunity to interview staff members. So it's completely at your discretion to elect which staff or which existing employees will transfer with the sale and continue their employment with you. Commonly for those employees who do transfer, you will be required to recognise their leave entitlements, which had previously accrued. This and relates to things such as sick leave, annual leave, and long service leave. So you just need to be aware that workers that have been in the business for quite a while and have significant liabilities for entitlements, that will now shift and transfer to you and become your liability. At this stage with the staff interviews, this is an opportunity for you to engage your own staff or employ your own members, or if you have preferred employees which you'd like to engage in the business. Also provide you with the opportunity to somewhat reset or tidy up staffing arrangements in the business, and tidy up any associated wage costs. However, as the staff have the relationships with the customers and have experience and knowledge in that business, particularly if they've been employed there for some time, there is a goodwill component and an expertise component attached to these staff, which contributes to the business. So it's important to consider these implications when considering your staff makeup and the staff moving forward. Another thing to consider in the lead up to settlement is stock take and the stock take procedure. Again, at the contract stage, this should have been determined and there should be a procedure set out for the counting of the stock, particularly what will be excluded if this is necessary to you. But things that you need to be aware of are that broken items, expired lines, discontinued lines should not form part of the stock purchase and not form part of the sale. This is also important in the event that you're engaging in a franchise agreement, then there will be certain lines or ranges which you cannot sell. So therefore, it must be considered at an early stage as to what stock should be excluded and what should come across with your purchase. Otherwise, you may be left with stock which you simply cannot sell. Some other basic items in the lead up to settlement as well include just setting up your wholesaler accounts and electing which wholesaler you'd like to use and the arrangements you'd like to enter into. And also just more generally, do you need to engage a bookkeeper? How are you going to manage your payroll? Are your trading accounts set up? Is your FPOS set up? So this is just to provide a general overview of the settlement process and the tasks to be completed. So I'll just pass it back to you now, Chris.
Great, thanks, Nico. I think one of the questions people ask or would like to know the answer to is what sort of cost is involved in all the legal assistance throughout this journey?
Yeah, so commonly the legal fees that you will see will range between 8,000 and 12,000. So next to the competency that you obviously look for in the solicitor, the other key component here with the transaction is to look for fixed fees, I guess more so than the price. Transactions can commonly just delay or unforeseen problems can arise. So, but traditionally the price range will be between about 8 and 12 for a pharmacy lawyer.
Okay, thank you.